Okay. Good morning. My name's Ken Gottlieb. I'll be your judge today. You are in a bond court, so you will not be having your trial today. That means you don't need to tell me all the facts of your case. In fact, everything's being recorded, so you might not want to put the facts of the case on record because anything you say can and will be used against you at your trial or motions that may occur during the pendency of your case. You do have a right to an attorney. If you can't afford one, one could be appointed. The public defender's there. I know he's been talking to you, and he can help you if you need any help. And we will decide today whether there's probable cause on your case and set a bond. That's what we're here for. If you have a question when you come up, you can ask. We're going to start with Andrew Jewell.
I think he was transferred from Maine yesterday, so I don't think he's there.
Page 15.
He's probably in
North Broward, I believe.
We have an issue with Paul.
North Broward, Judge.
Okay, I'm there. We'll go back to the order once we...
All right, Paige. Who is it that you need?
Andrew Jewell. Page 15.
Andrew Jewell? It's not North Broward, Your Honor.
Okay.
Paul Ryan. It's Paul Ryan. Yeah, it's Paul Ryan.
Do you have Andrew Jewell there?
Hey, bud. Oh, you just bring that one person from 1H?
Yeah, he's
Page 15.
I'm giving a call to Paul Ryan, Your Honor.
Okay.
He's on his way up, Your Honor.
Okay, we'll go back to order. We'll come back to Mr. Ryan, or Mr. Jewell. Not Mr. Ryan. Okay. Bianez Ramirez.
Judge, she's here present at Maine. She's going to be requiring a Spanish interpreter.
Okay, we'll come back to her because the interpreter's not here yet.
Yes, Your Honor. Toma asiento, por favor.
Sarah Zaki.
North Broward, Judge.
Thank you. North Broward, Sarah Zaki.
The name?
Zaki.
Oh, Zachy. Yeah. There you go.
Hello.
Good morning. You are charged with a touch or strike, battery, domestic violence. I find probable cause. State is...
I'm sorry.
Go ahead.
Your Honor, Ms. Zaki was arrested for battery 2015 that was dropped. She had a criminal mischief in 2013 that she was convicted of. 2013 domestic violence, another battery that was dropped. 2010 burglary of a dwelling and grand theft. She violated probation, 3-year state prison. 2009 burglary of a dwelling, theft, same sentence. Theft 08, grand theft, unlawful use of false name ID, and petty theft 09. 08 arrest for another battery that was dropped. 07 possession of oxycodone, alprazolam with the VOP. 07 burglary of a dwelling, possession of alprazolam, and theft with the VOP. Criminal mischief, unlawful use of false name ID, 06. Your Honor, based on her criminal record, the level of violence alleged in this case, state would be requesting a $3,500 bond and no victim contact.
Judge, respectfully, I'll be requesting a $1,000 bond. I can tell you that she's a resident of Sunrise, Florida. She lives with her parents. She's been living here for 20 years. She's a graduate of Piper High School. She's currently not working. Her mom is a school teacher. Her dad works in pharmaceuticals. They can afford about $200 towards her bond.
Please, Your Honor.
I also have an order of pretrial release.
That would be the no contact order.
Okay. This is what I'm going to do. I'm going to set bond based on her priors. I consider it to be a danger to the community. I'll do a $3,000 bond. And I will require no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't even drive by the victim. If you need to get clothing from the property or from the home, have someone else go for you. Okay.
All right, thank you,
Thank
Judge.
you.
What'd they tell you?
Adrian Daniels.
Adrian Daniels? Adrian Daniels?
I just took him outside.
Adrian Daniels. He's coming up, Judge. He declined the services as a public defender.
Okay.
He's coming up. Mr. Daniels, come on up.
Good morning, Mr. Daniels. You have been charged with a touch or strike battery, domestic violence. State, are there any priors?
Yes, Your Honor. In 2013, strong arm robbery. 2008, he was arrested for aggravated battery of a pregnant victim and child abuse. Charges were dropped. Felony possession of marijuana in 05 with the VOP. In 02, he was arrested for aggravated assault and battery. Charges were dropped. 2002 theft. 2001 theft. Your Honor, based on the level of violence and his arrest record, state would be seeking a $5,000 bond, no victim contact.
Okay. Based on its priors, I consider Mr. Daniels to be a danger to the community. I will set bond at $5,000. No victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. And if you need to get clothing from any property or home, have someone go and get it for you.
He's got a
Okay,
pending
thank
case
you.
also.
Have a good day. Isaiah Cameron.
North Broward, Judge.
Okay, Mr. Cameron,
No problem, Your Honor.
I find probable cause. You've been charged with aggravated battery. And state, does he have any priors?
Your Honor, first off, Mr. Cameron is out on release for pending grand theft auto. It is within the court's discretion to whether to revoke his release sua sponte or not. Possession of marijuana 2016, possession of marijuana 2015, delivery of oxycodone 2012, 44-month state prison as a habitual offender. 2011, burglary of an occupied conveyance, robbery by sudden snatching, grand theft, resisting without violence, 44-month state prison as a habitual offender. 2008, grand theft, 3-year state prison. 2008, grand theft auto, 3-year state prison. 2007, grand theft auto. Your Honor, the state on this matter, based on its prior record, level of violence, and the physical condition of the alleged victim, would be seeking a $15,000 bond, 1-5. If the court is not inclined to revoke his bond sua sponte, then the state would be requesting pretrial release supervision with the GPS monitor.
Okay, sir, did you want the public defender to represent you?
Judge, I did speak with him. He does.
Okay, because he's raising his hand if you'd like to say something.
Sir, yeah, he was asking me some questions about the probable cause affidavit. I can call him back and tell him details. I'm not going to make an argument as to probable cause. I think sufficient for probable cause. I would also note that she refused fire rescue and doesn't note if the officer observed any injuries. In light of that, Judge, I can tell you right now, he's currently homeless. There's not a bond he can afford right now. He does do lawn service and auto detailing. He has no money in the bank, no property. I would just ask the court not to revoke his bond and set a reasonable bond on this matter.
And what do you believe is a reasonable
A
bond?
reasonable bond, I would suggest $3,500. But the thing is, whatever number I give to the court, it's not a number he can afford.
Yeah. Okay, what I'm going to do is I'm going to revoke his bond based on his priors, being a danger to the community, and he's out on a bond, and he picked up this charge. He can file something with the court if he would like to reduce his bond. Or
So I got no bond on both charges?
He's
I'm revoking bond on the current charge of aggravated battery.
No, Your Honor,
Actually,
he's entitled to a bond on this. You're revoking on the grand theft auto, which for the record, and I'll prepare an order for the court, is case number 16-11826, CF10A.
yeah, I'll do that, and I'll give him a $15,000 bond on this. Okay? Narendad,
And I'm sorry, Your Honor, on camera, Mr. Cameron, we would also ask for no victim contact.
okay, I will do no victim contact as well.
Deputy, could you have Mr. Cameron come back, please?
Cameron, come back. Cameron. Hey, Cameron. He's refusing to come back.
Well, Your Honor, if you could order him to come back, he has to hear you. He has to be advised of the no contact order, or he can claim he didn't know.
Hold on, let me get him out.
Actually, could you take that
Push.
first stop out?
I just revoked his bond, so.
No, I know, but one, he can, hypothetically, he can make calls from the jail. Two, if the judge reinstates his bond and then he bonds out on this, then.
Okay.
Yes, Cameron.
In addition to the bond, if you do get out, there will be no victim contact, direct or indirect. You cannot go within 500 feet of the victim, no guns, ammunitions, or weapons of any kind, no calling, emailing, writing, texting, don't visit, or even drive by the
Sir.
victim. Yes, sir.
Sir, how can I do that if that's why I'm living there? That's my baby mom's. We stay together. How can I not stay there?
You can't stay there.
That's crazy.
Okay, well, have a good day.
You too, sir.
Okay, Narendra Mohan,
North Brad.
Yeah.
I find probable cause there's a capias on this case with a no bond hold.
Your Honor, this, and Your Honor, sorry.
Okay, I see the aggravated assault with a deadly weapon.
Yeah, it was originally aggravated assault with intent to commit a felony. It's still an aggravated assault, just a different type. We just asked for the original conditions to be kept in place, Judge.
Okay, I will keep the, and what was the bond on the original? Okay,
And a GPS monitor.
$10,000, your bond will be at $10,000 with a GPS monitor for pretrial services, okay? And
Okay.
no victim contact. You understand?
Yes, but where could I go? That's my house. The victim is living in.
You cannot go within 500 feet of the victim, no guns, ammunitions.
But I ain't got no other
House.
I ain't got no other place to go.
Don't call, email, text, visit, or even drive by the victim.
Oh.
If you would like, you can contact your lawyer, utilize the services of the public defender to figure out how you do that. Today is just to set the bond. Since it is an aggravated assault, we're going to have no victim contact on it. Okay?
Okay,
Have a
I
good day.
did. No, okay, thanks.
We have an interpreter here. Can we go back to Vianas Ramirez? Is that the interpreter case?
Yes, Judge. Viviana Ramirez, is that aquí?
Good morning, Your Honor. Theodore Leal, Spanish interpreter.
Okay, please raise your right hand. Do you swear to interpret from English to Spanish and Spanish to English?
Yes, I do, Your Honor.
Okay. Ms. Ramirez, you have been charged with a touch strike battery.
Señora, Ramírez se le está acusando de haber tenido una línea de tocar y golpear.
I find probable cause on the case.
Y en este caso encuentro que hay indicios de culpabilidad.
State, do you have any priors?
A ver si la fiscalía tiene antecedentes a revisar.
Your Honor, from what I can see, she has no criminal record.
No tiene ningún récord según lo que puede ver el fiscal.
State would be requesting a $1,000 bond and no victim contact.
Y se está pidiendo a la fiscalía que imponga una fianza de $1,000 y que no tenga ningún contacto con la víctima.
Judge, respectfully, in speaking with Ms. Ramirez, she's been residing in our community for the past 3 years. At this time, she's unemployed. She lives with her family. Her family helps
Hector,
financially.
Hector, you gotta let the interpreter interpret.
Okay.
con todo respeto, quiere decir que ella está, thank you, counsel, está viviendo aquí por 3 años, que no está trabajando, que ella ya está viviendo con su familia, no cuenta con el dinero.
Judge, like I said, financially she has no money in bank, no property. I did advise her, due to the domestic situation, she'll have to live separate and apart from the alleged victim. What I would ask you to do, considering her lack of financial resources or lack of criminal history, I'd ask you to consider an ROR at this time, Judge.
Y está pidiendo al juez entonces que le dé libertad bajo palabra, tomando en cuenta que no tiene dinero, que no tiene historial de antecedentes, y ese es el consejo que le he dado a ella basado en la situación, porque tiene que estar alejada de la víctima.
Does Ms. Ramirez qualify for pretrial? Okay. What I will do, she does have a residence, but she won't be able to go back to it. Is that become an issue?
She has to have somewhere else to go.
Ms. Ramirez, do you have somewhere else to go besides your current home?
Señora Ramírez, están viendo la posibilidad de darle una libertad, pero no puede volver al mismo lugar donde estaba viviendo. ¿Tiene algún otro lugar donde podría quedarse?
She said no, Judge.
She has no friends or family?
Ni amigos, ni familiares.
She's advising me no.
Okay, then what I'll do, I believe it will be easier, is I'm going to set a $500 bond. There will be no contact, direct or indirect, with the victim. She can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even go by the victim.
Entonces, creo que lo que va a ser más fácil es imponerse una multa de $500, prohibiéndose el contacto con la víctima directo o indirecto, que se acerque a 500 pies de distancia. No se le permite ningún tipo de armas, ni parque de municiones, ni contacto telefónico, ni por textos, ni por vías, ni por correo electrónico.
Thank you.
Judge, would you sign a photo order?
Yes.
Thank you.
Orden.
Counsel, just submit one to me.
There should be another Spanish.
There's another one?
Yes.
Oh, ¿alguien más que habla español? ¿Solamente español? Español. No one else here at Maine, Judge. I don't know if any other facility.
Do any of the facilities need a Spanish interpreter?
¿Alguien más necesita un intérprete en español?
Could you check La Vera, page 13?
North Broward School.
I thought.
Conti, do you need any interpreters?
No, Your Honor, no interpreter needed.
Okay, Paul Ryan, anybody need a Spanish interpreter?
Judge, maybe I think the last case may need an interpreter. Omar Yazasa. Is he at one of the jails?
Omar
He's at North
Yazaza.
Broward.
Deputy Garrett, does he need a Spanish interpreter?
No, he says he speaks English just fine.
All right.
Okay, great. Thank you. Have a good day. We'll call you if we need you. Thank you. Okay. Shane Keith Heffernan.
He's here, President Maine. He's approaching.
Thank you. I do find probable cause. This one, there's an, okay, I'll wait till he gets up here.
Five. Good morning.
Okay, this is an out-of-state hold felony, theft by taking, and there's a no bond hold on your case. Okay? Thank you. Widleen Ermott.
Ms. Irma, come on up.
Okay, on this, there's a capias. There's a hearing set 3/23 at 10 a.m. and the bond was set at $1,500.
Judge, In speaking with Miss Irma, she advised me that this is her only offense ever. She did not know she had court that day. She lives in Lauderdale Lakes. She goes to Florida Career College. She is a student. If the state can confirm that she has no prior offenses, Judge, would you consider an ROR and let her appear on March 23rd?
No, there's a capias outstanding in a judge that's a different division than me. And so I'm going to keep the capias what it is.
Thank you,
Okay.
Judge.
She has a hearing date on the 23rd.
Thank you.
Okay, Artavia Mills.
Any questions you have, just right now.
Okay, Ms. Mills, you've been charged with a petty theft. It's a first offense. The suggested bond is $25. State, any priors?
Checking that right now, Your Honor. I see there was wait. Failure to appear in Palm Beach twice last year. Another failure to appear 2014. All right. Another failure to appear 2013. So that's it. That's yes. I know that I said NCIC. Click on NCIC. Your Honor, these are all from cases that ended up being dropped, so, but it does appear there's issues showing up in court.
Okay, so she has no convictions.
Marty, the other
Okay,
female bonded out already.
Ms. Mills, I'm going to
Dillard.
keep your suggested bond of $25.
And
Okay, and I do find probable cause.
here's
Good luck to you. Lauren Perry.
That's no problem, Your Honor.
Judges, can we double check? It's a possession of drug paraphernalia, and not used to seeing no bonds on those.
it's
So
because
the
it's at a
failure-
drug court.
I'm sorry, which case?
This Lauren Perry.
Yeah.
I'm just not used to seeing no bonds on possession of drug paraphernalia.
I was actually in a program.
It's not uncommon for
Was
It's not uncommon for Judge Zeller to set no bonds to ensure that the defendant appears before her.
Okay, but it is a capias from a judge, not in my division.
Yeah, it's drug court, yeah.
And her hearing date is 3/22, so Judge Zeller can take care of it at that time.
I just wanted to let you guys know that I was in treatment when I missed that court date, but there was a case ran consecutively with that case. That's why I missed the court date. I was in treatment.
Okay, and in a few days, you'll be able to go in front of Judge Zeller and tell her that. Okay?
Okay.
Thank you.
Thank you.
Donna Baisden.
Go ahead, have a seat. Also North Broward, Your Honor.
Okay.
Good morning.
Good morning. You've been charged with criminal mischief. And state, does she have any priors?
Your Honor, I'm showing out of the state of Texas. One moment. Possession controlled substance from 2005.
Do you have a recommendation for bond on this? Criminal mischief, she
yeah.
walked through concrete.
Just let you know, she has a couple of prior failures to appear. Your Honor, I'm fine with the convenience bond. I just ask that they're.
How about if we resolve the case? What would the
The the only issue, Your Honor, is there could be a restitution issue. Normally with restitution.
I could take care of that. The restitution. I'm on disability. I could pay restitution.
Normally with restitution, there would be probation. It's hard to do probation out of here because the case is assigned to a judge. You're ordering the probation. If there was a violation, there could be another judge on the bench. But if that's the court's inclination, then I would advise, if you want to ROR her, I just ask that there be an order that she not return to the property where this allegedly occurred.
Okay.
No problem.
I will, based on the priors and the charge, I'm going to find probable cause. I'll ROR you. There'll be no return to that sidewalk.
That's fine.
What I would suggest to you is when you go to your first hearing, you might want to try to work it out. Maybe if you are prepared to pay the restitution, they might resolve the case for you then.
Okay, thank you, Judge.
Thank you. Caitlin Good?
Judge, I'm sorry to interrupt. Just to let you know, one of these orders, I can see your signature. I don't know how this computer is just you have a stamp on it.
Oh, she's on a better path.
Do you want me to sign over?
Yeah, I just didn't know if it was on the others also. Just to avoid.
You got a good girl.
I don't know. I didn't see the...
No, I am.
Okay. Is Caitlin Good here?
There you go. Not proud, Your Honor.
Okay.
So it's so loud in here, we can barely hear.
I'll try to talk up.
Thank you.
I can hear you.
Okay, on this, there's a violation of probation, which is set on 3/22 at 8:45 a.m. in front of the judge. There's a no bond hold on that, and there's a capias of $500. So I'm going to find probable cause, allow you to go to your hearing. Okay, good luck to you.
Thank you.
Yeah, and he's got.
Thank you very much.
Thank you. Janae Martin.
Your Honor,
Yes.
if possible, there's two co-defendants.
They're the last
She's approaching?
cases.
If we could maybe call them all at the same time.
Judge, I need to see a warrant on this. I don't have a copy of the paperwork.
Okay. We're going to call all three up at this time for the same charge. We have Janae Martin, Demetrius Elliott, and Omar Izaza. Are you all at the same
No,
place?
it's Kelvin Benjamin is the third.
Oh, okay. Calvin Benjamin. I thought it was the last one.
Good morning, Judge Ryan Kelly for the state.
Wait.
Hold on. You say Omar Izaza?
No, I
You want to
don't-
see them both together?
Yeah, I guess I called him by mistake. Maybe.
Judge, my understanding, Judge, Ms. Martin is here at Maine. I believe her co-defendant is also here at Maine. The deputies are informing me that they have keep separate orders on them, and also they're male and female, and they can't both be up here at the podium
Okay.
at the same time.
Then I'm gonna just call,
Ms. Martin?
I'll just call Miss Janae Martin. Miss Martin, you have been charged with 3 counts of tampering with a juror. No, count 4 is using a two-way communication device to facilitate a felony, and 5 was a probation violation of community control, which you do have a hearing on 3/27 at 8 a.m., and there's a no bond hold on the probation violation. I do find probable cause. State, are there any priors?
Yes, Your Honor. In fact, she was a co-defendant in the case in which she tampered the jurors on. She was not pending trial. She resolved her case pleading guilty to burglary in the 2014 case. She pled guilty on February 15, 2016, and the charges were 2 counts of burglary dwelling, 1 count of grand theft. She also has a prior grand theft.
What's your
And a petty theft.
recommendation on bond for counts 1 through 4? The recommended bond was $1,500 on each.
Your Honor, due to the nature of the charges, we're seeking $15,000 on each count.
Okay.
Judge, the defense would be fine with the standard convenience bond. I see on count 5, though, she is being held no bond. She's on probation, so she's not going to be coming out regardless. We'd be asking you to set the standard bonds. And the only other additional request we would have is, we see she has a court date coming up on March 27th, and she is a mother, she has kids. Is there any way to get an earlier court date to be seen in front of her probation judge?
No, I don't. That's set in front of another judge, so I don't have any control over the other judge's docket. So, no, I cannot set the case earlier, but if she utilizes the services of the public defender, maybe your office will have some luck at doing that.
And she would qualify as a violent offender of special concern as well. which would require a danger hearing for her to be released.
Okay. I do consider her to be a danger to the community based on her priors, and I'll set bond at $10,000 on each count. And count 1 through 4, there's a no bond hold, so she will be able to take care of that when she has her hearing. Okay, thank you. All right. Christina Dalhouse. Once I get a couple done, that way they won't have to interact with each other. Okay, Ms. Dalhouse, you have been charged with, well, you have a violation of a probation felony with a no bond hold. It's set for the 22nd at 8:30 a.m. Okay, I find probable cause and will allow you to go to that hearing on the 22nd. Okay, good luck to you.
It should.
Okay. LaToya Grant. Okay, Ms. Grant. Ms. Grant, you have been charged with battery on an officer and resisting officer with violence. I find probable cause. State, does she have any priors?
She's not on our list. I don't believe she has any priors. Does pretrial have any notes?
Okay, did you have a recommendation for a bond on this?
Your Honor, based on the allegations, I'd be asking for a $2,500 bond on one, $500 bond on two.
Judge, there are some mental health issues. I did speak with her. She's a resident of Broward County 19 years, currently lives in an apartment in Dewey Street. She lives by herself. She doesn't have much. She's telling me that she used to be a bank teller, but is currently unemployed. She'll be relying on her dad to bond her out, but hasn't had contact with him. In line with the fact she has no prior record, would the court consider pretrial release pending verification?
Does she have a place to live when she...
She told me she has an apartment off Dewey Street in Hollywood.
Okay, then, based on her connections to the community, I'll ROR her on both counts, and I will give her pretrial release, the standard pretrial. Okay, thank you.
Thank you.
You can step back in, okay?
Okay. Let's go back to Demetrius Elliott. Can we bring him up?
They're going to get him right now, Judge.
No, only reason. I'm gonna keep my mouth shut. If not, if you want to come in on a
You still got one more key?
Everybody's done, let's go.
Female.
What page is Demetrius Elliott at,
He's
Judge?
like the last case, second to last case. Page 26.
Thank you, Judge.
Here. What's that name?
Demetrius Elliott, page 26. These are ad charges.
Yeah, oh, here it comes.
I wonder if he has...
Does he have a private account?
We'll ask him.
Yes, he has a private attorney.
Your private counsel should be there.
Counsel? All right. Armstrong. Okay, no, that's not. Okay, his attorney is not here.
Are you on probation? On patrol.
Who is your attorney?
Jason Rosner.
Jason Rosner. He's not here at this time. Is he planning to come?
How long you live in South Florida?
Your Honor, I haven't heard from him.
Married to the little horse. You live alone.
Do you want to roll it over to the afternoon?
That's fine, Judge.
We'll roll your case over till the afternoon and wait for your attorney. Maybe he'll come. Okay? We'll contact his office so that he has an opportunity to come. Okay. Thank you. How about Kelvin Benjamin?
Hold on one second, Judge.
Does he have a private lawyer too?
Thank you, baby.
I don't know where they're going to get him right now. It was a keep separate, so they have to keep them separate, Judge.
Yeah, that's why I've been calling him so. Thank you.
And if that's not there, then it means that there was a warrant, but there wasn't, so they arrested him on 486. So let's, this is a perfect example. Let's say they start to, Judge, we want you to set a bond of VOP. Well, remember, now, nothing here would qualify him, but robbery with a firearm or deadly weapon would qualify him as a violent offender of special concern. So because he's on probation for that, he would have to have what's called a danger hearing, and it's called a danger hearing, and only the judge that put him on probation or that division can give him a bond.
Sorry, can you pull up Benjamin?
Yeah.
Okay, Mr. Benjamin.
He's approaching, Judge.
Yes, I see him right there. He has been charged with count 12 and 13 with tampering with a juror, and count
How old is he?
No, that's fine.
15 using a two-way communication device to facilitate a felony. I find probable cause based on the probable cause affidavit. State, do you have any priors?
Your Honor, he does not have any adult priors. He does have several pending charges, including robbery with a firearm, armed kidnapping, aggravated battery, robbery with a deadly weapon, Wow. He's got six charges, 6 different cases, including robberies, all of which he is pending to stand trial. In light of that and the facts of the underlying case, in ordinary circumstances, if he was out of custody, we'd be moving to revoke his bond on all those cases. Considering he's in custody, we just ask for a $25,000 bond on each count.
Okay, and what's the reason you're asking for more on him than
Based on the nature of the charges that are pending against him, his status as an inmate in the jail, and his involvement in the juror tampering. He was the actual one on the phone.
Devontae Martin.
Yes.
Judge, in speaking Mr. Benjamin, he's already being held on numerous other charges. I believe he's held on a no bond hold. He is represented by the public defender's office. He's unemployed, no money in the bank, no property. He was going to Hallandale Adult trying to seek his GED, so therefore he hasn't worked. We'd be asking you to just keep the standard bonds in place.
Okay, in light of his pending cases and priors, I am going to set bond at $15,000 on each case and find probable cause. Okay, thank you.
And the other one bonded out already.
Yeah, she.
For this guy.
Okay, let's move on. Denisha Johnson.
No.
What's the case?
Armstrong. It's coming up, Judge. You on page
I have to have a seat. I'm ready to leave. I don't care.
It's coming up.
That's what I figured.
Denisha Johnson. Hello, you have been, you're in on a capias, no bond hold. The status is set for 3/29 at 2 p.m.
You'll be seeing the judge March 29th at 2 p.m. ma'am.
Katrina Hall.
She bonded.
Okay, I did find probable cause, but bonded is fine. Okay, Catherine Marshall.
North Broward, Judge.
Okay, Miss Marshall, you have been charged with possession of cocaine.
Let me check. Obviously for you.
State, does she have any priors? I
You're on-
find probable cause.
Call you soon, come on.
I'm showing an old DUI, but nothing else, Your Honor. As far as release, whatever the court deems appropriate in your discretion.
Okay, Miss Armstrong, or I'm sorry, Miss Marshall, Do you have a job?
Judge, she told me that her mother contacted a bondsman to bond her out. I would either ask for an ROR or keep the bond as it is. She does have a lot of medical issues.
Does she? So she has a place to live?
Yeah, she does.
Okay. Then based on your ties to the community, I'll keep the bond at $1,000, and
It's not letting me print you.
you can bond out with the help of your mother.
Oh, no, I just wanted to print you.
Good luck to you.
The warrant, I really appreciate that. No, no,
Thank
no.
you.
It won't let me print it.
Angelica Bristol Jackson.
North Broward, Judge.
Okay. You have been
Yeah, yeah, that's
charged with 4 counts of DUI, 5 is driving with your license suspended, and 6 is an open container. I find probable cause. State, does she have any priors?
Yes, Judge.
Oh, DUIs. My first DUI.
Yeah, it's a DUI, count 1. Count 2 is damage to property of a person. 3 is damage to property of another person. 4 is DUI over a .15. So,
Your Honor, I'm showing a 2005 violation of a protective injunction. 02, she had 2 separate possessions of cocaine, 1 possession of cocaine with intent, a little over 17 and a half months state prison on the cocaine cases. Possession of cocaine, 01, battery, 99 with a VOP, end of record.
Ms. Jackson, do you have a place to live?
Yes, sir.
Okay, are you represented by the public defender?
I believe so. Yes, sir.
Okay, did you want to just tell me about her ties to the community?
Yes, I do. Ma'am, can you living here all her life. She lives in a 2-bedroom house. You live in Fort Lauderdale, right?
Well, I used to stay there years ago, but I've been staying with my boyfriend for 10 years.
What city?
And I stay in
Pompano Beach. She works with scrap metal with her boyfriend. She hasn't had an opportunity to contact her boyfriend. She pays about $950 a month towards her rent. In light of the fact she's been here all her life, Judge, I would ask this, some pretrial release. They do have a monitor called a TAD monitor, which could detect whether or not she's taking alcohol or not. Will the court consider
So
that?
is she eligible for pretrial?
We have not been able to make a verification on her behalf. The court is inclined to release her. I would suggest that she be placed pending verification.
Okay. What I'll do is then I'll keep count 1 at $500. I'll make count 2, 3, and 4 ROR pending pretrial release. Otherwise, it will be $500 on each count. Can I do that?
You can whatever he pleases, but I would suggest if you're going to reduce the bond, you can reduce it and leave them all in place. And then if we verify her, then she'll go on pretrial.
Okay, but if she goes on pretrial, I only wanted her to pay the $500.
So you do want her to post a bond.
I want it to be a total of $500 with pretrial.
Remove all the bonds, put the $500 and plus pretrial. I heard the.
But if she
PD
doesn't qualify for pretrial, it will come back, is that?
Well, here's the thing, I heard the PD asked for her to get a TAD monitor.
Yes.
If you're gonna put her on a monitor, then we won't let her out until we verify her anyway.
Okay.
So what the court can do is leave her
Okay.
on at 500.
That's what I'll
You
do.
can do ROR 2 through 5, and then put TAD. You're gonna put bond plus TAD.
Okay.
Thank you.
That's what I'm gonna do. I'll reduce the bond to $500 on count 1, ROR on count 2, count 3, count 4, count 5. We'll put her on pretrial and TAD.
What's tag?
What's that?
Alcohol evaluation.
Yes, that's the phase 2 or 1?
We'll do the alcohol evaluation, and then she has to put all recommendations at the top of the detective sheets.
Okay, that's how I want it. Thank you.
They don't want cops who.
All right, good luck, ma'am. Laisha Briggs.
Telling me I just have a just have a $500 bond,
Yeah.
and then I get on pretrial or something like that.
Laisha Briggs, I've been advised judge bonded.
Okay. Thank you. I find probable cause she bonded. Marlene Danny.
North Broward judge.
Okay.
Thank you.
Miss Danny, I find probable cause. You have been charged with driving with your license suspended, and you had a capias with a bond of $1,000. You have a hearing date set for 3/22 at 9 a.m. And your bond is set on the DWLS at $750. I'll reduce that to $500. Okay, good luck to you. Yeah.
That's it.
We're going to skip to Andrew Jewell.
Your Honor, because of the issue with the audio over there, he's going to be standing at the podium. He's not going to be able to hear what I'm saying, but I've just discussed with him on the phone. He understands.
Which court is he?
He's in Paul Ryan.
All right.
Make sure you get the.
Okay, Mr. Jewell, you have been charged with lewd and lascivious exhibit with a 16-year-old victim or less.
Correct. I'm not sure
It's
he can hear you.
count 3 on as an add-on charge.
That's correct.
I find probable cause.
Judge, before you do that, I'd like to make one comment about the PC, even though I'm certain.
You can do that?
Okay. The allegation in the probable cause affidavit apparently is coming from the alleged victim himself. The PC is it's a hearsay statement from the alleged victim. The issue that I have with this is we were here 2 days ago. The victim gave a lot of commentary towards law enforcement, which is what the first 2 charges were predicated on. It was very detailed, and this particular piece that they're now adding, which is a pretty intense piece of information, was overlooked and was not discussed at all. Let me finish. For a second, one
Give
second.
him a
That
chance.
wasn't-
I will.
It wasn't in the probable cause affidavit as it was here 2 days ago. Judge Levy-Cohen did levy 2 bonds on that particular case. Those bonds now, as I understand it, have been posted by a signature-only bail bonds, but of course he has not been released because of the ad charge. What I am going to ask for, and I'm sure it's going to sound greedy from the outset, is I'm going to ask that Your Honor ROR him on the 3rd count. The reason being, as this is added, any additional bond that Your Honor may consider imposing, I'm not going to say that it's tantamount to a no bond hold, but he will not be able to bond out. There's zero money that could be put towards this. I had 7 family members in my office the other day to contribute to a down payment on less than 50% of the first 2 bonds that were levied. So any monetary amount won't be able to be accomplished. At that point, I'd ask Your Honor maybe attach some pretrial conditions or whatever else you deem is appropriate. There's no criminal history that he has that reflects this type of alleged behavior. There is, and Mr. Linder can correct me on the charges because I might misspeak, they're theft charges. It may be a uttering of a forged instrument or some sort of grand theft charges that he had a couple years ago, and that's the entire basis of his criminal history.
Okay, I am going to find probable cause. I've reviewed the probable cause affidavit and believe there to be probable cause. Okay, with respect to the bond amount.
Your Honor, well, first, I just want to...
Like to argue, you don't have to argue about the probable cause.
No, I'm not arguing about the probable cause. I just want to explain because it was put on the record that...
You don't have to explain. That issue's over. We just need to pick a bond amount. Just
Your
tell me
Honor,
about the prior.
based on these new allegations, Your Honor, I'm going to be asking for a $10,000 bond.
Okay, and what is the basis of that? What are the priors?
Well, Your Honor, the basis is he has a prior uttering of forged instrument, 2 counts, and 1 count of grand theft. Your Honor, I'm basing it on the allegations contained therein. This is new information that was not provided to Judge Levy, obviously, when she set the bonds. This additional information only raises concerns, Your Honor, also based on the age of the alleged victim. And I would also note, Your Honor, the law does not support the argument that the court setting a bond today, even 10,000 would be tantamount to no bond, simply because the family can't afford to pay it. There's more factors to take in consideration than just what the family what their financial situation is, and certainly wouldn't rise. 10,000 on a second-degree felony with these allegations, I do not believe would rise to the level of tantamount to no bond.
Your Honor, if I may, before you impose the
Sure,
bond.
no problem.
The primary charge, of course, which was on the last probable cause affidavit, I believe that was set as a $10,000 bond. We now have the additional bond that's on count 2. The purposes are to prevent risk. He has no history of missing prior court dates. He was born in Broward County. His mother and father were born in Broward County. His grandparents were born in Broward County. He has significant ties to Broward County. He's a financial advisor in the community there where he does reside in the Tamarack area. There's no reason that I see that the state could compel Your Honor to levy that bond based on his ability to flee, or he's not a risk, is the short end of my story here, Judge. So pre-trial, I'd love to ask for that.
I will find that he has ties to the community, but based on the allegations within the probable cause affidavit, I am going to set the bond at $10,000.
Your Honor, would you, I know where you, and I am trying to change your mind, but I know in this case that you may not. With that being said, as the bonds have been posted already for the first 2 counts, would Your Honor consider a GPS monitor and the pretrial release conditions only on the 3rd count? The monetary amount's already been paid to the best of his ability.
On the 3rd count, if you would like, I could do the $10,000 and the GPS monitor when he gets out.
I would not like that. I was just asking for that in lieu of the monetary amount.
No, I'm not going to do that.
Okay.
Thank you.
I appreciate it.
I appreciate your argument. Thank you. Lizette Jermison.
I've been advised medical loan, Judge.
Okay. Need me to say we'll do a medical reset.
Thank you, Judge.
David Scher.
Mr. Sheriff, come on up.
Those are prior.
Okay, you're in on a capias. The bond was set at $500. I'll find probable cause, and you'll be able to appear in front of the judge where your case is. Okay, thank you. Nathaniel Martin.
Nathaniel Martin, come on up, please.
You're next. After this one, please.
You're next. Okay, Nathaniel Martin, you have a capias set at $1,000. Your hearing will be set in the division which you were in, MD. Okay, good luck to you. Thank you, and I found probable cause. Okay, the next case is Austin Armstrong.
Mr. Armstrong, come on up.
Okay, your attorney is here. It's a violation of probation with a no bond hold.
Correct, Judge. Judge McHugh's case. Mr. Armstrong, I'm here for Max Carrio's friend. Can you hear me, sir?
I can hear you.
Great. Chris Mancini. Sorry, Judge.
He has a violation of probation in Division MV. It's to be set in the division.
Yes, Judge.
And it's a no bond hold.
Not much I can do about
Not
that,
much I
Judge.
can do.
I
It's already
understand.
set.
Do we have a status date on this?
No, I don't see one, but you can set one. I'm sure she will.
Okay. All right.
Thank
That's all we
you.
can do today.
Michael Hummel.
Good morning, Your Honor.
Good morning. You have a violation of probation, no bond hold. It's set at 3:22, 9 a.m. in the morning. Okay?
Thank you, Your Honor.
Thank you. Good luck to you. Okay, we have Michael Howes.
Mr. Howes is approaching, Judge.
Okay, Mr. Howes, you have a violation of an injunction, protection, domestic violence. State, does he have any priors? I do find probable cause.
One moment, Your Honor. Do you see anything in the house?
Out of Collier County, 2011, he had a domestic violence battery. And a domestic violence battery by strangulation. Both counts were dropped, Your Honor. 2006 out of Naples, DUI conviction. Is anything else?
That's it, I think.
I don't see anything else, Your Honor.
Anything to add?
Your Honor, just I would be asking, based on the allegation of violating a current order from the court not to have contact, I'd ask for a $2,500 bond, no victim contact.
Okay, does Mr. House have a... Okay, did you...
And speaking, Mr. Howes, I believe this injunction is in reference to, I believe it, 6 years ago. This is an incident where it happened on a cruise ship. I believe him and his family were boarding a cruise. He currently lives in Naples. He has 3 children, ages 15, 13, and 5. He is self-employed. He's a handyman. He's been doing that for about 3 years. Judge, his whole family is on the cruise ship. He has, at this point, no one to bond him out. I did tell him because this injunction, he has to live separate and apart from the alleged victim until this case is taken care of in court. Judge, what we'd be asking you to consider at this point is either an ROR or setting this as a $1,000 bond, Judge.
Okay. I'm going to find probable cause. I do consider him to be a danger since he's had repeated violations over the years. I'll set bond at $2,000. And thank you. Raphael.
Your Honor, is the court ordering
and
no
no
victim
victim.
contact?
And I'm sorry, sir. Come on up. I did forget to tell you. I did forget to tell you, no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting. Don't visit or drive by the victim. And if you need to get clothing or property from the home, have someone else go for you. Okay.
Judge, the only additional request then the defense would be making is, like I said, the victim and this gentleman share 3 children in common, ages 15, 13, and 5. He shares in their life as far as to and from school, taking care of them. Would you allow, for purposes of arranging child visitation, could they go through a third party? So that, therefore, Mr. House doesn't have to have any sort of contact with the alleged victim.
I believe that was already covered by the injunction out of Naples. Your Honor, I would just ask that you order that he has to follow the conditions of the injunction.
Okay. I do not have a problem with him trying to raise his kids the best he can. I support that and will allow him to do that. And if he follows the injunction order that was required in the underlying case, that would be fine.
Okay, so Judge, you are allowing it through a third person. Thank you. Okay.
Yeah, they'll no third-party contact for child issues. Counsel, can you just write up the order for that?
See what I'd like to do on some of these injunctions.
However you want it.
I go to civil.
Thank you. Raphael
That was in my
Lovera.
other system.
We're going to need a phone order, Mr. Opsal. Mr. Rivera, come on up.
Sir. I'd like to pull the petition to see what was being alleged.
We just did that. Sir, you have a violation, injunction, protection, domestic violence. State, does he have any priors? I do find probable cause.
Your Honor, first off, I'm showing 2005 aggravated fleeing and eluding and felony DUI. He was sentenced to 5 years in state prison. 03 DUI, 02 DUI, 01 battery, trespass, resisting without violence. Your Honor, I can also tell you, I'm just looking over the petition from the injunction. Apparently, it was alleged by the petitioner. She asked him to leave the home. He refused. She ran into her room and locked the door to get away from him. He kicked the door in. She was in fear for her life in the previous incident. The police report was taken. The neighbors the neighbors came out and called the police and on her behalf. Your Honor, based on that and the allegations here, I'm going to be asking for a $10,000 bond. $10,000 bond, no victim contact, pretrial release with a GPS monitor.
Okay. Counsel.
Judge, in speaking Mr. Rivera, he's been residing in South Florida for about 28 years. He is 48 years old. He is a handyman by trade. He makes approximately $400 a week on a good week. Judge, I did explain to him, he will be living separate and apart, no contact with the alleged victim. He'll be residing in Boca. I know the state read off his priors. I believe the priors are over 10 years. Judge, we'd be asking you to set a $2,000 bond on Mr. Rivera and ask you to sign a phone order allowing him access to a phone so he can try and contact his family to potentially bond him out, Judge.
Okay, I'm going to agree to the phone order. I will set bond at $5,000 based on his priors being a danger to the community. Also, I have no contact, direct or indirect, with the victim. You can't go within 500 feet of the victim. No guns, ammunition, or weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. And if you need clothing or any property, have someone go for you. Thank you.
Judge, may I just recall a case that you addressed earlier, reset for the afternoon docket? A Demetrius Elliott. It was a tampering case with a juror. His attorney called me. He informed me that he has court on Monday, and that he's asking that if the court would, with regards to the ad charge, put it on Judge Usan's docket because he has other cases before Judge Usan on Monday.
That's kind of irregular, right? His client's entitled to a bond hearing today.
I'm sorry, who's this on?
Demetrius Elliott, page 26.
Jason Rosner called me. He's asking if the matter could be placed before Judge Usan on Monday. I'm not going to be here this afternoon. I'm just telling the court that he called me.
I mean, I can tell you if it's, and I understand the court's position, I guess if it's his own attorney that's making the request, I mean, certainly I can't imagine Mr. Rosner's going to file an appeal since he's the one making the request.
I don't think he would appeal it. It's just, I don't even know what kind of docket Judge Usan has.
Well, no, that's what I'm saying.
8 or 9 case. He has other charges too that are before Judge Usan on Monday.
Well, Your Honor, if I could have a moment, I just want to call Mr. Kelly to see if he has no issue with that.
Okay, you look into it. It's set for 1:30 right now. We'll deal with it when you get an answer.
Sure.
Okay, because I don't want to keep wasting time.
Sure.
I want to get through the docket. Everybody who's here. Robert Bolton.
Mr. Bolton is approaching. He's here at Maine.
Okay, you're here on a violation of probation. There's a no bond hold, and you have a hearing set before the judge on March 23rd at 11 a.m. Good luck to you. Stephen Octavic.
Judge, he's approaching. Judge, Mr. Octavic has asked me to request your honor if you would consider resolving his case for time served.
Okay, it is an option. I do find him probable cause. It's a disorderly conduct state.
Put down 500.
Do you have an offer in the case?
Your Honor, I don't have any priors. Don't see any priors. I'd offer him withhold court cost judicial notice of time served if he wants to resolve it.
Okay,
Listen to the judge.
it's a withhold court cost. Would you like to accept that offer?
Yes.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Do you understand English?
Yes.
How far did you go in school?
I graduated high school.
Do you understand the charge?
Yes.
Do you wish to enter a plea of no contest?
Yes.
Do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes.
And do you understand you have a right to an attorney, and do you waive that
Yeah.
right?
Yes.
Okay, I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and I'll sentence you to a withhold court cost. Credit for judicial notice of time served.
Okay.
Thank you. Michael Sullivan.
Michael Sullivan, been advised bonded, Judge?
Okay. Thank you. I do find probable cause. Scott Matthews.
Judge, he's approaching. Judge, Mr. Matthews is also, this is a municipal ordinance case. He's advised me he wanted to resolve the case, so he'll let you know.
Okay, Mr. Matthews, if you would like, it'll be an adjudication court cost. I do find probable cause. Would you like to accept that?
What would that be?
An adjudication of guilt, court costs of $293. I'll give you a year to
Yes.
pay.
Yes, Your Honor.
Okay, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. Do you understand English?
Yes, Your
How
Honor.
far did you go in school?
12.
Do you understand the charge?
Yes.
Do you understand you have a right to an attorney, and do you waive that right?
Yes.
Do you wish to enter a plea of no contest?
Yes.
And do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes.
I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and I'll sentence you to an adjudication court cost. Credit for time served. Good luck to you.
Thank you, Your Honor.
Thank you. Michael Seitz.
Mr. Seitz, come on up. Judge, Mr. Seitz has also asked me to ask Your Honor if you would consider resolving his case for time served.
State, do you have, I find probable cause. Do you have any priors?
He does have history, Judge. Trespass, loading and prowling from January. Trespass, December. Trespass, 2015. Violation of injunction and trespass, 2014. Stalking and trespass, 2014. Trespass 2013, Trespass 2011, Berg Structure 2011, Trespass Resisting Without 2011. Goes on from there, Judge.
Okay, how many days has he served?
He was just arrested last night, 7 o'clock.
If you would like, it'd be an adjudication court cost 5 days credit for time served. Would you like to do that?
Yes.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Do you understand English?
Yes.
How far did you go in school?
12th grade.
Do you understand the charge?
Yes.
Do you wish to enter a plea of no contest?
Yes.
Do you understand you have a right to an attorney, and do you waive that right?
Yes.
Do you understand if you are a citizen of the United States, regardless of whether you're a citizen of the United States, whether you are here legally or not, this plea will subject you to deportation? Do you understand that?
Yes.
Court finds you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea. Based on the documents in the file, I find a factual basis for the plea, and I'll sentence you to an adjudication court cost 5 days, credit for time served. Thank you. Good luck to you. Jose Garcia.
Mr. Garcia is approaching, Judge. Judge, Mr. Garcia is approaching.
Okay, I find probable cause. He's in on a capias, which is set at $500.
Judge, Mr. Garcia is inquiring if you would consider resolving his case today. He believes, or we believe it may be out of Publix, in which the merchandise was recovered, so there would be no outstanding restitution. We'd be asking you if you would consider resolving his case today.
Okay, based on the nature, state, do you have any priors?
2016 theft, 2015 battery on a law enforcement officer resisting with violence, 2012 theft, 2011 burglary of a conveyance, theft, carrying concealed weapon with a VOP, 2011, false impersonation of a police officer and battery with a VOP. 2009, criminal mischief. 08, DUI.
Okay, on this, I'm gonna find probable cause. I'll keep the bond at $500, based on him being a danger to the community, and I'll let him resolve the case in division. Thank you.
Yes, Judge.
Joshua Wellington.
Mr. Wellington, come on up, please.
Whatever? No, is it resident?
Sir, you've been charged with driving with a suspended license, operating without a valid license, and an improper backing. State, do you have an offer?
One moment, Your Honor.
And any priors?
That's, yeah.
I
I'll
find
check.
probable cause.
Yeah, Your Honor, looking at his driving record, I don't think I'd be able to make an offer. I mean, I'd make an offer of jail if he wanted to resolve it, but I don't think he would. And any other offer would, for me, would have to include probation. His driving record is really poor.
Okay, but do you have any priors?
Yeah, okay, Your Honor, just looking at his driving record, he had a fleeing or eluding law enforcement 2011. His driver's license was revoked for a year on that. DUI 2012. Picked up for a failure to appear in Palm Beach, also with the burglary of an occupied dwelling. Trying to see, it looks like that might still be open. With a grand theft and false verification of ownership on a pawn item. Possession of marijuana, Palm Beach, 2000.
I'm gonna just set the bond at the required $100, and he can take care of his driving issue in front of the division. Thank you. Devontae Martin.
Devontae Martin, are you
Why
here?
would he access this to send from where?
It says Maine, 8C. Maine
He's in
8C.
the cell, go get him, Martin.
Oh, he's in the cell? Okay. He's gonna be brought, Judge?
Okay, so we'll skip him. We'll come back to him in a little bit. Marcus Melton.
Marcus Mullen, come on up, please.
Okay, he has count 6 and 9 are capious felonies. They're both set at 12. Well, one is set. Count 6 is set at $1,200, and count is it a? Let me check.
This is on Marcus Milton?
Yeah.
Oh, we're just here on 8 and 9.
Okay, yeah. It's hard to read
Oh,
the
they're-
type.
so
it didn't come through too well.
they're each
There was a
1,000.
capious for 1,000 and a capious for 1,000. He has a status on that on 3/22 at 8:45 a.m. So
Thank you, Judge.
he can attend. Thank you.
Mr. Martin has been brought back, Judge. This is Mr. Martin, right? Mr. Martin is here.
Okay,
Devontae
Mr.
Martin?
Devontae Martin.
Come on up, please.
You see, just when it starts with 1, that means these are good charges. and
Okay.
Just go to.
You have an add-on charge
Look here, you just
introducing
like BS
contraband
pigs.
to the detention facility. State, did you have a recommendation?
Your Honor, he's being held no bond on count 1 for premeditated murder, with a $7,500 bond on count 3. I'm just going to ask that the convenience bond be kept in place.
Okay, I
$1,000.
do find probable cause.
Just let me
Counsel,
know.
did you have anything to add?
No, he's being held no bond, standard bond, and the defense is fine with, Judge.
Okay, I'll just do the standard bond of $1,000. Thank you.
Thank you, Judge.
Azari Aroka.
That's no problem, Your Honor.
Okay, Mr. Aroka, you have a capious felony with a no bond hold. And you have a status hearing on 3/22 at 8:30.
Judge, he's entitled to a bond on this case. The state filed information. Count 2 is an ad charge.
Your Honor, he's being held on count 1 $75,000 bond for a burglary with assault or battery. Just going to ask for a $5,000 bond.
Judge, and just give you a little bit information about him. He is a resident of Kendall, was living there for 4 years, was a supervisor for Pegasus Painting, owns a home with his wife that's currently, he was refinancing. His mortgage on that property is about $1,200 a month. I believe the incident happened December 2016. He may have some defenses where he may have been attacked, but I would ask the court to set a $2,500 bond on count 2.
Okay. Any objection to that, State?
It's fine, Judge.
Okay, I will set bond at $2,500.
Your Honor, what are my charges? I couldn't hear it.
Well, you're in on a capias, a felony capias. That's
Oh,
what's
okay.
on the battery for a person over 65 was the charge.
Okay, all right. And so I just got. What happened to the aggravated burglary? They
Your
got dropped
lawyer-
down.
This is an add-on. That's you're being
Oh.
held on a no bond, and your lawyer just reduced your bond to $2,500.
He's going to be arraigned by Judge Robinson Tuesday morning.
You'll be in front of Judge Robinson on Tuesday.
All right, thank you.
Thank you. Good luck to you. Brian Mahia. Are you here on something? Which one?
Judge, he's here present, Judge. He declined the services of public defender, Mr. Mejia.
Okay, Mr. Mahia, you have add-on charge of grand theft and fraud uttering a false instrument. Does he have any priors?
He's being held on counts 1 through 5 for 2 grand thefts, 2 uttering of forged instruments, and a robbery by sudden snatching. 1,000 on each, so I'm just going to ask that the convenience bonds be kept in place.
Does he have priors?
You want him on the pre-trial? Bond or pre-trial? Or you want him on, I didn't ask you if you have, or you want him on.
I just see the cases he's being held on.
Okay. I find probable cause, and I am going to keep the convenience bond at $1,000 on count 6 and 7. Good
Thank
luck
you.
to you, sir.
Thank you.
Judge, can we do a gentleman out of turn? Mr. Joshua Abrahams, he's on page 24 of the docket, towards the end.
Yes.
Thank you, Judge. I know he has a medical issue, and that's why I wanted to try and call
No
him
worries.
up
I do find probable cause on Joshua Lee Abrams. He has a violation of probation set for 3/22 at 8:30 in the morning. It's a no bond hold on that.
I'm sorry?
Do you have any argument, or you want to keep the convenience bond?
With the no bond hold, I'm fine with everything as it is.
Defense is fine with the convenience bonds, Judge.
Okay, I'll set count 1 at $100, count 2 at 1,000, count 3 at 100, and count 4 at 1,000. Count 5 is a no bond. Thank you,
You'll be
sir.
seeing your judge March 22nd at 8:30 a.m., okay? Take care.
Hope you feel better. Ma'am,
Thank
what
you,
was
Judge.
your case? Yeah, we're gonna skip ahead, going to Eric James.
Eric James, what page is he on? Eric James.
It's near the beginning, or near where we are.
Okay, Eric James.
Okay, you are charged with possession of a weapon
Mr. Griffin?
or ammo by a convicted felon. State, do you have any priors?
Yes, Judge.
And I do find probable cause.
His priors include 2010 domestic violence battery by strangulation and battery. He violated probation. He went through drug court in 08 for delivery of cocaine, 07 for possession of cocaine with intent, 05 possession of cocaine with intent, was sentenced to just under 30 months state prison, 04 possession of cocaine with intent with a VOP, same sentence, possession of marijuana with intent, 03 resisting without violence, end of record.
Okay, did you have a recommendation for a bond?
Your Honor, a moment.
Do you have any children?
Going to be asking for a $2,500 bond.
Okay.
Judge, in speaking with Mr. James, he's been residing in South Florida his whole life. He is 31 years old. At this point, he's unemployed. He's looking for work. Right now, he lives in Fort Lauderdale with his mother. They rent an apartment. He's going to be relying on her to bond him out. She works at Advanced Auto Parts. He just recently had back surgery, so that's why he's unemployed. He's dealing with his back issues. Judge, considering his ties to the community, his lack of financial resources, we'd be asking you to consider a $1,000 bond on Mr. James' behalf.
Okay, and there's someone here. Did you want to speak on his behalf, or did you just come to watch? You don't have to speak. You're just here, so I wanted to let you.
Sorry.
Okay. Thank you. Okay, I will set bond at $2,000.
Thank you, Judge.
Thank you. Thank you. Good luck to you. Nasser Zaki.
Mr. Zaki is here present, Judge.
You have been charged with a battery causing bodily harm, fraud, and knowingly giving false information to a law enforcement officer. You have a capias on count 2 and 3. The capias is
Not in custody cases.
$3,500 and the other one is $100. The battery convenience bond is $1,000. And you also have a status hearing at 3/22 at 8:30. State.
Yes, Your Honor. I'm showing trespass 2015, a DUI 2015. One moment. Your Honor, I think based on the monetary amounts under which it was filed, the fraud between $20,000 and $100,000, I think the convenience bonds are appropriate.
Okay.
Judge, the defense is fine with the convenience bonds. His parents are going to be bonding him out.
Okay, I will let the convenience bond stand based on priors. I find probable cause. The battery will be $1,000. The fraud is $3,500, and the count 3 is $100. Thank you. Good luck to you. Okay, Richard Edwards.
Mr. Edwards, come on up, please.
Misdemeanors. Been arrested before?
I do find probable cause. You've been charged with neglect without great bodily harm to count 1 and 2. Count 3 is driving with your license suspended. Count 4 is reckless driving. Count 5 is fleeing and eluding. Count 6 is flee, attempt to elude law enforcement. Does he have any priors?
Yes, Judge. His criminal history includes possession of cocaine, 2015, 20 and a half months state prison. DWS habitual offender, 2015, 20 and a half months state prison. 2014 DWS habitual offender, 20 and a half months. An arrest for child abuse in 2014 that was dropped. Possession of marijuana with intent to sell, 2012 with a VOP. 2011 felony battery, domestic violence by strangulation with a VOP, 364 days. DWS habitual offenders in 2011, 2 more in 2010. Resisting without violence, 2010. DWS's 2 more in 09. DWS habitual offender in 08. Possession of cocaine, 08. DWS 07. Delivery of cocaine, 02, 30 months state prison. Possession of cocaine with intent, 2000. Your Honor, in addition to his priors and the allegations, obviously I have a concern. Mr. Edwards continues to drive when he's not supposed to. In this incident, he put the lives of 2 children at risk and obviously I think based on the allegations, he also has to be considered a flight risk since he refused to stop for law enforcement and fled.
Okay, counsel?
Judge, in speaking with Mr. Edwards, he's been residing in South Florida his whole entire life. He is 36 years old. At this point, he's currently looking for employment. He was previously working, however, he was working for a pressure cleaning company. He was making approximately $11 an hour. Financially, though, he has no money in bank. He owns no property. He lives in Deerfield. He lives with his grandmother. He's been residing at the same residence his whole entire life. He has 8 children whenever that he has to provide for. Right now, that's why he's currently looking for work in order to provide for them. Judge, what we'd be asking you for is to consider setting a reasonable bond. As to count 1 and count 2, we'd be asking you to consider setting $1,000 each count.
Okay, I will set bond because of his ties to the community, balanced with his danger to the community. I'll set bond at $1,000 on count 1 and 2 as requested. And I'll keep the convenience bond the same. Count 3 will be $750. Count 4 will be $100. Count 5 will be $2,500. And count 6 will be $1,000. Okay, thank you.
SBU.
Ronald Damon.
Mr. Damon? Oh, come on up, please.
I find probable cause. There's a violation of probation on a felony with a no bond hold, and it's set for 3/23 at 9 a.m. Good luck to you.
Yes, Your Honor. Thank
March
you.
23rd, you'll be seeing your
Well,
judge.
you before or someone?
Avery Sutton.
Mr. Sutton, come on up, please.
He has an aggravated battery causing bodily harm. He has a capias with a no bond hold, and it's set for status 3/22 at 8:30 a.m.
Judge, he's
Actually,
entitled
he
to a
is a-
bond.
Okay,
It's a non-in-custody warrant.
so are you gonna argue?
Your Honor, he has a 2000 burglary of a dwelling and stalking, 4-year state prison as a habitual offender, 99 battery, 1992 armed burglary of a dwelling, 2 counts of robbery with a firearm or deadly weapon, 9-year state prison, 1990 possession of firearm by convicted felon, 2.5-year state prison, 1990 carrying concealed firearm with a VOP, 2.5 years, carrying concealed firearm, 89, possession of cocaine, 87. Your Honor, based on his prior acts of violence, including, based on these allegations, I'm concerned that he has a prior stalking and priors with firearms and the level of violence alleged in this case. I'd be asking for a $15,000, $15,000 bond, no victim contact, pretrial release with a GPS monitor.
Judge, and speaking with Mr. Sutton, he's 52 years old. He's been residing here his whole life. He just attained a job. He's working for AC Logistics. He's going to be making about $15 an hour. Financially, though, he has no money in the bank, no property. He lives in Deerfield Beach. He lives with his mother. He's been residing at that same location for the past 3 years. And if I heard the state correctly, Judge, his last felony offense was about 17 years ago. We'd be asking you to consider setting a reasonable bond. We'd be asking you to set a $2,500 bond on Mr. Sutton's behalf.
And how much were you asking, Stan?
15,000.
And when was his most recent crime?
His last significant prior was a 2000 Berg dwelling where he was sentenced to 4 years in state prison.
What year?
2000, but I just want to note, Your Honor. One moment. Okay.
Nobody else calls me on this phone line.
Released from state prison in 03.
Okay. I'll do $7,500 bond. Pre-trial release. No victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing or any property from the home, have someone else go for you. also will require the GPS monitor.
Judge, only one thing I believe.
Is the defendant allowed to work?
Yes.
And it's court finding the indigent and waiving the cost of the fee.
Oh, yeah.
If not, it's a $5 per day fee for the defendant.
I am not going to, I haven't heard that he's indigent at this point. Thank you. Bye.
Judge, basically, like I said, he has no money in the bank, no property. He just obtained his employment, making $15 an hour. He filled out a financial affidavit this morning with the public defender's office. We believe he's going to be determined to be indigent by the clerk of courts. So at this time, we'd be asking you to consider waiving the cost of the monitor. Also, Judge, I just wanted for clarification, you imposed a no contact with the victim, but you didn't impose any sort of distance requirement. Is that correct?
We'll make it 500 feet, which...
The reason why I bring up that
right?
specific issue is the neighbor.
Yes, I understand.
So
500 feet should cover that, right?
No, that means he would have to not live at his house. I would ask you if you would consider, like, it's across the street or next door.
I'm gonna, Your Honor, if I can.
That across the street.
It's across the street, right
20
in front
feet
of him.
then? Would you lower it to 20 feet? Because then I think...
We don't have.
I can't...
I can get the distance. I just need 1 minute to put in the addresses.
Okay. We're gonna have the state attorney figure out the distance, like how far it across the street.
Thank you.
But I will grant your motion and waive the fee based on indigency.
Thank you, Judge.
And just so the court knows, I have been told I don't see the right on electronic monitor when the distance is too.
The children are yours.
Things like that.
Biological.
Tends not to function as accurately because we map it and they tend to overlap with their that close.
Okay. Thank you. Yeah.
Your Honor, it's 98 feet, but frankly, I mean, I still would be asking for 500 feet. This man, even if they're neighbors, he still has, my understanding is it's not his home, it's his mother's home, so you're not evicting him from his home. The alleged victim has a right to not have any contact and not
Okay,
have.
but him going to his house shouldn't affect that.
The problem is it's about 100 feet away. That might be too
Judge.
close for, excuse me, that might be too close for a GPS monitor.
Judge, and the only additional information I want to point out, this is a not in custody case, so it didn't happen just like yesterday. It happened some time ago. He's been living there. There's been
Allegedly in May.
In May, there hasn't been any sort of incident.
Okay, counsel, I'm gonna reduce it to 95 feet. If it doesn't work, the division judge can take care of the no victim contact order.
Okay, but it's the court's intent not to have this gentleman not go to his home, correct? You just don't want him to have any sort of contact with the alleged victim,
This
correct?
would allow him to go home, he just can't interact
Perfect,
with the
perfect.
with the alleged victim.
Perfect, that's the intent of the court. Thank you.
Douglas Staffa?
Judge, I would waive formal reading of the charges. If that's the situation, if we could handle them at the end of the docket, if we need to go into certain issues.
Okay,
Thank you, Judge.
take him at the end. Cesar Velasquez?
Cesar Velasquez, come on up.
I find
No
probable
bond hold.
cause,
There's nothing
you're
we
on
can
a
do.
no bond hold for a violation of probation, which is set at 3:22 at 8:30 in the morning. You have a fleeing and eluding, a driving with your license suspended, attached registration, and an unlawful speeding.
Your Honor, I would be asking for a $5,000 bond on count one. based on he's on probation for armed burglary and he's fleeing from law enforcement, I've got concerned that he could be a flight risk if he should be eligible for
Does he
bond
have
at some
any other
point.
priors?
One moment, Judge.
Do you owe anybody any money? For the zero?
Just the two felony cases on probation. I would also note, Your Honor, on the armed burglary dwelling, it's not showing. He was also charged with grand theft of a firearm. He was sentenced to 42 months in state prison on a youthful offender status and followed by probation. So it's even of more concern that the risk of going back to prison wasn't enough to allegedly prevent this. He's driving, also noting he's, as far as financial ability, he's driving a 2009 BMW.
Okay. Do you have any argument, counsel?
Judge, it's a VOP, no bond hold. He's not going anywhere. We'd be fine with a $2,000 bond.
Okay. I'll set a $2,000 bond on count 1 based on his priors. Count 2 will be an ROR. Count 3 will be an ROR. And count 4 will be an ROR. The count 5 and 6 are no bond holds. Okay, thank you.
Meeting here, Judge, March 22nd.
Trayvon Griffin.
Mr. Griffin, come on up, please.
B or a C?
Sir, you, I find probable cause. You are
18.
on a capias, $500. Count 1. Count 2 is a violation of probation with a no bond hold. Count 3 is a violation of probation with a no bond hold. You have a status on 1 on 3/23 at 10 a.m. and the violation of probation for the felony is 3/22 at 8:30 a.m. Good luck to you. Baron Andrew.
Mr. Andrew, defined to serve as public defender.
Okay, sir, you have a resisting without violence, a capias in a felony with a no bond hold, and a capias with a felony on a no bond hold. You have a status on 4/3 at 8:30 a.m. I will keep the bond at $100 for the resisting the officer. Good luck to you.
All right.
Thank you.
All right.
Morel Jones. Morel Jones.
Yes, sir. Good morning.
Is your name, Judge?
Good morning.
I find probable cause to robbery with a weapon and an aggravated battery. State, does he have priors?
One moment, Your Honor. He does, Your Honor. 2008 manslaughter, 2008 possession of oxycodone, 2006 disorderly conduct, 2002 traffic fleeing and eluding. Your Honor, actually, I'm sorry. He also has 2009 burglary of a dwelling, 2014 possession of PVP, 25 months state prison, 2014 resisting with violence, battery, and criminal mischief, 25 months state prison. Your Honor, based on these allegations, the fact that Mr. Jones has violence in his past, including a manslaughter, I do believe he poses a danger to the community. I'd be asking for a $50,000 bond on 1, a $25,000 bond on 2, count 1 being a first-degree felony. Pretrial release with a GPS monitor, level 1, and no victim contact. Frankly, I don't think there's any mitigating factors, even assuming he has no money, great ties to the community, a job, all that stuff. I don't see how those could possibly outweigh the violence alleged in this case and the violence he's committed in his past.
Okay.
Judge, and speaking with Mr. Jones, he is 30 years old at this point. He's looking for work. He was previously employed. He was working at the YOLO restaurant in Fort Lauderdale. He was a porter, making approximately $10 an hour. He has no money in the bank, no property. He lives in Fort Lauderdale. He lives with his mother, been residing at the same location for the past 30 years. He has 2 children, ages 2 and 4. He's not the primary residential parent, but right now he's helping out whenever he can as far as taking care of him when the mom has to work. Judge, what we'd be asking you to do is consider setting a bond of $5,000 on count 1 and $5,000 on count 2 with pretrial.
Say that again? I didn't hear what you asked for.
We'd be asking you to set $5,000 on count 1, $5,000 on count 2 with pretrial release.
Okay, based on what I'm hearing, I do find him to be a danger to the community. I'll set bond on count 1 at $50,000, count 2 at $20,000. I will, if he does manage to pay his bond, I'll put him on pretrial release with a monitor and GPS. What else were you requesting?
Well, I was requesting a level 1. I understand we're being advised he has a job, but I just think the danger he poses to the community is just too great and a risk to.
Okay, I'll do level 1 with a GPS.
And obviously, we'd ask for no victim contact.
And no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. And if you do need to get anything from the victim's home, have someone else do it for you. And if there's any other circumstances, you could bring them up before the division judge. Thank you.
Yes, Judge.
Marquise Williams. Okay.
What's this? I just sent it.
You have possession of an unlawfully issued driver's license and a petty theft. State, does he have any priors?
Marquise Williams. One moment, Your Honor. I'm showing. Okay. Resisting Without Violence, 2016 out of Palm Beach. Failure to appear and a Resisting Without Violence, 2016 in Palm Beach. Another failure to appear, 2015 in Palm Beach. Sale of cocaine, 2013 in Palm Beach. Another failure to appear, 2012 in Palm Beach. Another failure to appear. Possession of cocaine, 2012 in Palm Beach. Failure to appear, 2012. Failure to appear, 2010. Failure, 3 more failures to appear, 2010. Burglary of a structure, 09. Failure to appear, 08. And in the past, a woman also obtained a injunction order of protection against Mr. Williams.
Go ahead, counsel.
Judge, we'd be asking you to consider pretrial release, considering this is a nonviolent offense. Judge, he did advise me that he is employed. He works as a day laborer, making about $52 each day he works. He lives with his girlfriend in Palm Beach. They have 5 kids. Both him and his girlfriend work and are trying to provide for their family. Financially, though, they don't have any sort of monetary resources to post the $1,000 bond, and that's why we'd be making that request of pretrial release.
Just doesn't go to court.
Okay, I'll do the convenience bond on count 1, which is $1,000. Count 2, I'll do an ROR and put him on pretrial.
Marquise Williams.
Marquise Williams. Any request for any questions pretrial?
No, Your Honor. We weren't able to verify.
You were not.
We were not able to make a verification.
Okay, counsel, does he have a place to live?
He did advise me he lives with his girlfriend in Palm Beach. Judge, if what we'd be asking you to consider is if you are imposing the monetary bond of the convenience standard bond of $1,000, we'd ask you if you would consider deleting then the pretrial condition.
Well, he has a history of not showing up to court that's very long, so I think he deserves both.
So it's bond and pretrial. Okay, that's fine.
Because he has to go to court.
That's bond and standard pretrial, correct?
Yes.
Thank you.
Ronnie Hoggins.
Good morning, Your Honor. Decline to serve as public defender, Judge?
Okay, Mr. Hoggins, you've been charged with grand theft, 20,000 to 100,000, obtaining property over $2,000 by fraud, or 20,000. Grand theft, 500 to 5,000, and grand theft, 300 to 5,000. You have a capias on all counts.
This is a not in custody capias, Your Honor. First, as far as his prior record, he had a theft in 04, attempted murder, first degree, robbery with a firearm or deadly weapon, and ag assault with a firearm. In 93, he violated his probation and sentenced to 17 years state prison. Battery, 95. Robbery with a firearm or deadly weapon in 91, 6 years state prison. Your Honor, I'm going to be asking, because of his prior record, and frankly, just to be more in line with the amount he allegedly stole, which is almost 25,000, I'm going to ask that count 1 be raised to 15,000.
Count 1?
Yes. I would make it a total bond, I guess, of 27,000.
Sir, please
Yes,
raise
sir.
your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Okay, do you have a place to live in South Florida?
Yes, sir.
How long have you lived there?
At my current residency, I've been there 2 years.
Do you have a family or friends to help you?
Yes, sir.
Any bank accounts, bonds, assets of any kind?
Rare, very rare.
You have rare bank accounts?
I just started with my employment. My money is very shallow. I don't have that much money, Your Honor.
Okay. Thank you. Based on your priors,
My priors, sir, not to interrupt you, but there was 25. Those priors are for 23 years ago, when I was 18 years old. I'm 42 years old now, and I haven't been in any trouble since then.
okay.
I was 18 years old. I'm 42. I haven't been arrested and been in any trouble since then. And the cases that I'm here before, Your Honor, those are civil. Those are civil cases that have been converted into criminal. And quite frankly, Your Honor, I shouldn't be here. Those are civil cases that I had in civil court that the prosecutor wants to convert into criminal cases. And they're basically cases where I sold cars to people. No, listen, no. I sold cars.
Okay,
no.
sir, you're getting into the facts of your case.
Yeah, because I have nothing to hide, and
Okay,
I didn't do anything wrong.
all today we're doing is discussing the bond amount. I don't want you to put something on the record that might incriminate yourself for the future.
I didn't do anything, so I have nothing to hide.
I'm just advising you that, okay?
Thank you, I appreciate it.
Just a couple things I want to bring to the court's attention. I was going to bring them up. Mr. Hoggins has brought those into the picture. He said he's not been arrested since the offenses that he went to prison on. That's not true. He was arrested 2015 on a grand theft that was dropped. He was arrested.
We don't need to go into
This is the same thing. This is the same thing.
I'm gonna set bond on count 1 at $10,000. I'm gonna set bond at count 2, $10,000. I'm gonna set bond on count 3 at 1,000 and count 4 at 1,000. Good luck to you,
And
sir.
Your Honor, we'd ask for no victim contact with a Michael Buster.
No victim contact with Michael Buster. You can't go within 500 feet of him. No guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. Okay, Rock Caesar L.E.
Mr. Elliott, your present charge at Maine?
I find probable cause. Counsel, any priors?
One moment, Judge.
You are been charged with grand theft between $300 and $5,000.
Okay.
Bond was posted? Okay.
His bond was posted, Judge.
Mr. Ellie, your bond was posted.
Your girlfriend already posted your bond. You'll be released today. Oh, your wife. I'm sorry. You'll be released.
Colin
Take care, sir.
Sweeney.
Mr. Sweeney is approaching, Judge. He's declined the service of public defender. Yes, Your Honor.
Okay, I find probable cause. You've been charged with delivering cannabis within 1,000 feet of a school child care park. Count 2, delivering cannabis within 1,000 feet of a school or child care park. 3, delivering cannabis within 1,000 feet of a school or child or care facility or a park. Count 4, possession with intent to sell or manufacture or deliver cannabis. And count 5, drug paraphernalia. State, do you have any priors?
Your Honor, he had a DUI in 2014. I'm just asking that the convenience bonds be kept in place.
Okay, sir, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Your Honor.
Okay, do you live or do you have a place to live in South Florida?
Yes, my parents.
You can put your hand down if you want. How long have you lived there?
My whole life, 21 years old.
Okay. And do you have a job? Any assets?
Yeah, I work at Top 42.
Do you have
Mr. Garnett?
any assets, a car, bank accounts, anything like that?
I have a car, yeah.
Do you own it or lease it?
I make payments on it.
Okay. How much are the payments?
$220 a month.
Any other assets of any kind?
No, sir.
Anyone to help you with your bond?
My parents, maybe.
Okay. State, you recommend the convenience bond?
That's all I'm asking for. Your Honor.
Okay, I'll keep bond at $1,000 or $5,000 count 1, $5,000 count 2, $5,000 count 3, $1,000 on count 4, and I'll ROR the count 5. Good luck, sir. Have a good day. Damian Clunas.
Damani Clueless is here. Clueless is here present, Judge.
Yes, he has a capias, count 2 for $250. Count 1 is delivering cocaine within 1,000 feet of a school, church, care, or park.
Okay. So yeah,
Your Honor, out of Broward, 2008. Sale, delivery of cocaine. He was sentenced to 2 years state prison. Just based on that and the fact that he didn't show up to court on count 2, I'm just going to ask that the convenience bond on count 1 be kept in place.
Okay, I do find probable cause. Counsel, do you have anything to offer?
Okay, I got Judge. I know Mr. Clunas is trying to argue that it wasn't willful, but I advise him at this point there's nothing we could do for him. That he's going to have to take up with his division judge on March 22nd. So at this time, standard bond and the defense is fine with.
Okay, yeah, just so your client understands, today is just about bond. It's not about your defense. So today, I'll set the convenience bond $7,500 on count 1, and the capias is $250. Thank you. David Patterson.
Mr. Patterson's here present, Judge.
Okay, you've been charged with possession of cannabis, possession of a weapon or ammo by convicted felon, resisting without violence, a capias on a felony with a no bond hold, and a violation of probation with a $2,000 bond. You do have a status on 3/22 at 8:30 a.m. and on your violation of probation hearing on 3/22 at 1:30 p.m. State, did you have anything to offer?
No, Judge.
He has any priors?
One moment.
David Brown?
One moment.
While he's looking, do you have any argument, counsel?
Judge, he's being held no bond on the capias out of Judge Bailey's division, and he's also on probation, Judge, on count 2. We'd just be asking for a $2,000 bond.
Okay, I'm just gonna do, on the possession of cocaine, it's 1,000. On the possession of a weapon or ammo, we'll put it at the $2,000. The resisting with officer will be 100. The capious is a no bond hold, and the violation of probation's 2,000. Thank you. Good luck.
Thank you, Judge.
Dalvin Garnett.
Mr. Garnett is approaching, Judge.
Okay, I do find probable.
Judge, Mr. Garnett declined to serve as public defender.
I do find probable cause.
Your Honor, if I may.
Yes.
He, count one should just be a misdemeanor first offense. I don't see two prior, I don't see two prior offenses. The standard bond would be 300. If the court's, I would ask the court to find probable cause for the misdemeanor.
On count one?
Yes.
Okay. On count one, I'll find probable cause for the misdemeanor prostitution. Count two is a possession of cocaine, and count three is a possession of Xanax, and count four is possession of cannabis. Bond will be set at $300 on count one. The others are possession of cocaine will be $1,000 bond. Possession of Xanax is 1,000. Possession of cannabis, count four, will be 100. Okay, sir? Have a good day.
Yes, sir. You too.
Ashkan Arzan.
Mr. Arzan, come on up, please.
I do find probable cause. He's charged with possession of cannabis,
I thought.
tampering with or fabricating physical evidence, and probation violation or community control, which he has a no bond hold. He does have a violation of probation hearing, 3/22 at 9 a.m. On count one, State, did you have a recommendation?
No, Your Honor, I'm fine with just one being no bond, 1,000 on two, and the VOP hold on three.
At this time, defense has, we're fine with the convenient bond, considering he has a no bond hold, and he'll be seeing his judge March 22nd, 9 a.m.
So the possession of cannabis, you wanted like $500?
No, I'm fine with it's because of the structure. The felony gets the bond, the misdemeanor doesn't in this situation. I'm fine with it being left at ROR.
Okay, on ROR count one, the bond on count two is 1,000, count three is a no bond hold. Thank you.
Thank you.
Anthony Nichols.
Judge, count two should just be false name to Leo. Don't know. Obstruction.
Okay. I do find probable cause, State.
It's fine. And Judge, with the no bond holds, I'm just asking that the bonds be left in place.
Okay, it's a no bond hold on count 3, 4, 5, 6, and 7. Count 1 was set at 3,500. We'll keep that. Count 2 will be an ROR. Status is set 3/23 at 8:30.
Thank
luck to you,
March
sir.
23rd at 8:30 a.m. You'll be seeing your judge.
Yeah.
David Brown,
David Brown.
come on up.
You have a violation of probation. It's a no bond hold. Your hearing is set 3/22 at 9 a.m. I find probable cause. Thank you. Quelly Boyer.
Shouldn't be.
Come on up.
Matter to me.
Okay, sir. You have been charged, I find probable cause, to a false ID given to a law enforcement officer, possession of cannabis, and probation violation of or community control, which there's a no bond hold on. The convenience bond for the possession is 100. I'll keep that. And the false ID given to law enforcement. State, did you have any recommendation?
I'm fine with the convenience.
Well, it's 0, so is that an ROR?
Yeah, yes, that would be.
Yeah.
Okay, I will give an ROR to that. Good luck to you, sir. Kurt Anderson.
Mr. Anderson's approaching, Judge. He has private counsel, Mr. Stephen Melnick.
Mr. Melnick is not going to be able to be here today. We sidebar. I don't want. There's information I don't want to put out over the internet. To go for today.
Okay, Mr. Anderson, you are represented by Mr. Melnick. I could find probable cause and give you these standard bonds, or you can reset this for tomorrow. He cannot be here today, but he might be able to be here tomorrow. Would you like to do that?
Can I ask a question first?
You can.
What are the bonds?
Well, let's start with count 6. It's $75,000. Count 1 is $1,200. Count 2 is $7,500. Count 3 is $1,000. Count 4 is $2,500. Count 5 is $1,000. Count 7 is $2,500, and count 8 is $100.
Can I get a total?
And you can, but it's over 70.
I just need to know if I have the money to get me out if I make a phone call with the total. That's why I would like to know the answer before I choose to move forward.
Judge, you'd also have to set a bond on count 9.
Oh, I didn't. And count 9. Okay.
Because, you know, like, she knows when I'm different from people, she could have
It'd be about 90,600.
So I need $9,600 basically with a bond me?
Well, we have to decide what the bond on your last count is. Is that something you'd like to wait till tomorrow or no?
Can you say that one more time?
Mr. Melnick might be here tomorrow. If you'd like to wait till tomorrow, he can argue to reduce your bonds for you.
I would like to do that. I've had a hard time contacting him. Are you guys going to contact him for me?
I'll contact him.
The state attorney has been in contact with Mr. Melnick. That's why we know he will not be here today, and he will contact him.
So Mr. Melnick knows I'm here?
No, but
Mr. Melnick knows that he cannot be here today. The state attorney will talk to him. We could reset your case. You could go over it with the judge tomorrow. And Mr. Melnick might be here on your behalf.
We can do that, but is there any way I'm able to get Mr. Melnick's information so maybe I can make my free phone call to him? Because I was just going to call a bondsman and have them like try to help me. If you could do that, or maybe I could see him today. I'm just having a hard time contacting him. Yesterday when I got here, I was here for like 8 hours. I couldn't use the phone.
Okay, the state attorney will tell him to contact you.
Thank you very much.
And I'll reset
So we'll
this
set
for
this.
tomorrow.
Yes, sir.
Good luck to you.
Thank you.
Francis Barrington.
He's approaching. He's here, Judge at Maine.
Okay.
Who is this?
You've been charged with robbery with a firearm.
Oh, Your Honor, I'm sorry.
There's a no-bond hold.
This matter was reset from yesterday. Could you give me the?
Yeah, because of a medical reason.
No. What happened was, okay, it was a change of charge. He went before, as you could see, he went before Judge Robinson on March 15th for his arraignment, and Judge Robinson wrote on remanded custody with COC capias.
Yeah.
Judge Fry wanted clarification on what Judge Robinson's intent was. I received word from the lead prosecutor in Judge Robinson's division. She brought it to his attention yesterday afternoon, and he told her his intent is to hold Mr. Francis no bond when he ordered him to be remanded. So we'd asked the court to hold him pursuant to Judge Robinson's stated intent on the record yesterday to hold him no bond, and that's really all we can do today.
Okay,
Well, Judge, may I respond? Just brief. It's our position, Judge, that holding him no bond on a punishable by life offense unless the state proves proof evident presumption grade or the intent to file a motion for pretrial detention is an illegal detention. The burden of proving proof evident presumption grade is solely on the state. It's a burden that is higher than beyond a reasonable doubt. I haven't heard that they're filing a motion pursuant to 3.132. this issue is, the issue of the bonds on the punishable by life offenses are currently.
Yeah, I also, just so you know, I do see a capias, no bond hold by Judge
It was a
Cohen.
change of charge. It was transferred from Judge Cohen to Judge Robinson.
It still looks like there's an outstanding capias.
Well, no, that's what it was basically, it was served on him when Judge Robinson ordered him to be taken into custody at his arraignment.
But so there was a capias.
Yeah, came from, we upfiled the charge, Your Honor. The clerk's office
Change of
upon the
charge,
upfiling created the capias.
Okay.
Draw my motion.
And I apologize, Judge, Mr. Afzal was not here yet.
Okay, I'll find probable cause, I'll keep the no bond hold, and the Judge Robinson can deal with it.
Yeah, it just, was it, hold on, I just want to see something.
Ome Izaza.
Judge, this issue is up before the 4th District Court of Appeals. They issued a stay order. So I guess nothing to. And they issued a rule to show cause too.
Because you guys filed, I don't know if there was a mistake, because I know you guys, Vivian Garibaldi filed a motion for ROR in front of Judge Colro, which was denied, I think within the past few days. All I was going to be asking the judge to do is not to make any findings today, just to hold no bond pursuant to Judge Davis's previous findings, which you guys have filed a writ on.
Well, if it's an appeal, I have no jurisdiction to do anything.
Well, it's a writ. It's not, I don't know if it holds, because, like I said, the defense also is, one moment, Judge.
Just might just have a moment to contact my appeals people, because we just got an order from the 4th District Court of Appeals on this case.
Okay, then while you're trying to figure that out, can we go and didn't we have Douglas Staffa?
Correct. He's on recall. He's on page 17 of the docket.
Yes, sir.
And what were we waiting on that for?
No, I just wanted to wait for a reading of the charges, and I know the state might have wanted to go into certain issues, so to be on the safe side, we reset it so he could be at the end of the docket.
Okay, State, did you want to tell me something?
Yes, I did, Your Honor. I just need one moment.
I do find probable cause. You've been charged with direct, promote sexual performance by a child and person in state transmitting child.
Yes. Okay, Your Honor, obviously your court is familiar with the allegations. Your Honor, the state is going to be seeking bonds on each case, each charge of $35,000, pretrial release with a GPS monitor. I can tell you, not only based on the allegations, Mr. Staffa was arrested in Minnesota in 1994 for criminal sexual conduct in the first degree, penetration of a victim between the age of 13 and 15 when in a position of authority. I don't have a disposition, but the arrest, Your Honor, does, and based on these allegations, does cause concern for the safety of the community, notably any minors in the community, Your Honor.
And do you have any other priors other than that?
An arrest for domestic violence battery in 06 in Alachua County. That is all I have, Your Honor.
Okay. Counsel?
Judge, as you heard, his priors were about 10 years ago. And speaking with Mr. Staffa, he's been residing in South Florida for about 13 years now. He is 45 years old. He is employed. He works in construction. He makes approximately $10 an hour. Financially, though, he has no money in the bank and no property. He does have family that resides in the community. He lives in Sunrise with his mother. They rent a house. The approximate rent on the house is about $1,800 a month. His mother is elderly. He's the caregiver of his mother. Judge, what we'd be asking you to do is consider we'd be asking you to keep the standard bond in place for count 2. And as far as on count 1, we'd be requesting you set that at $15,000.
Okay, you're requesting $15,000 and $1,000, and you're requesting $35,000, $35,000. Okay. I'm gonna set bond based on the danger to the community and what I've heard. I'm gonna set bond on count 1 at $35,000, count 2 at $35,000. Okay, and I do find probable cause. Thank you. Other than Omar Izaza, do we have anything else left for the morning? Which case? We still have that Rosner case, too.
Oh, yeah.
Oh, I gave that to you. Okay, that will come up. Okay.
Well, I guess we'll deal with that. No, I know, I mean, if you want to come, if you'd like to tell you now, I spoke to Mr. Kelly, or you want to just deal with it when we talk?
No, I want to deal with it after Izaza. We'll talk about it. What are we waiting on Izaza for?
He's here, President North Broward, Your Honor.
Judge, even though the matter is before the 4th District Court of Appeals, the court, it's up there on the issue of habeas. The court still has jurisdiction to set bond. My argument is, if the court were to hold no bond, the state has a burden of proving proof evident presumption grade, or
Isn't that the issue that you're up on appeal?
It's that issue, and also, Your Honor, I provided a copy of Judge Davis's original findings. As you can see, it's essentially, it's the same charges, sexual battery by someone in a custodial or familial situation. It's still a PBL. All I'm asking the court to do is to keep Judge Davis's previous findings in place, and the 4th can still rule upon that.
Our position is that his detention without a finding of proof evident presumption grade, or the state proving that.
Okay,
is
but if you
detention.
wanted to have that hearing, you could have had that hearing as quick as you want in the division, as opposed to here, where I have no evidence in front of me whatsoever. So I'm going to follow Judge Davis's ruling at this point in time and keep it at a no bond hold, or in effect, take no action. And I also don't understand how it could be brought up again if that's the specific issue that's on appeal.
Your Honor, if I may, we filed a technical change of charge from one subsection to another, and that created, the clerk's office created a capias, which they had to send to the jail to serve him with the capias, and then the jail had to put him back on. But essentially, it's the same allegations.
Yeah. Okay. Well, and
Your Honor, may I speak?
No, don't speak.
Sir, don't talk about what happened. You have an attorney, Vivian Garibaldi. You got to speak with her, okay?
Yeah, you have a
No,
lot of
he
legal
speaks
issues
English.
that are pending. They're working on your behalf, so it's in your best interest not to speak. Thank you very much. Okay.
Thank you, Your Honor.
Judge,
Thank you.
Judge, back at Maine.
Yes.
We just want to know for clarification, Demetrius Elliott, what are we doing with that case? That was, I believe, with Jason Rosner.
Yeah,
Is it going
I
to be
think we're
resent
gonna
for
take
this
that up,
afternoon,
but
or delete it?
Well,
Sure, we could call.
I can tell you right now, I spoke with Mr. Kelly, who spoke with Mr. Rosner, and they both are okay with bringing the matter up before Judge Uson on Monday. So all I would actually do now, if the court's okay with it, is make a finding a PC, leave the bonds where they are, and the bond issue will be dealt with by Judge, in front of Judge Uson.
I did find probable cause. We'll allow for the bond to be set in front of Judge Uson.
Thank you, Judge.
Okay, I'll tell the deputies not to bring him this afternoon. He's canceled. And Judge, what time are we going to be starting this afternoon?
Sometime between 1 and 1:30.
I know here they're telling me we always start at 1.
Yes, I'm going to try and get as close to 1 as I can.
Thank you, Judge.
Thank you.
It's okay.